Right, sir. With your permission, may we please begin?
Yes.
Right, sir. Hello, everybody. Good afternoon. I am Dakshita Dubey, co-convener of the Chanakya Center for Alternative Dispute Resolution. Along with me, I have Priyanshi Jain, third-year member of the center, and we shall be your moderators for the session. In case of any difficulties during the lecture, please feel free to drop us a message in the chat box. Further, we request you to hold all questions till the end of the lecture. It is a matter of great honor for me to welcome our guest for today, Mr. Prakhadeep, Principal Associate at Samco. Accompanying sir is Ms. Adya Joshi, Associate Samco. Even though our speakers for today need no introduction, I will share a small brief about our experts for the day. Mr. Prakha specializes in commercial remedies involving infrastructure, real estate, development projects, supply contracts, and business exit agreements related to arbitrations and its ancillary litigation in the High Court and the Supreme Court of India. Sir regularly advises and represents Indian and foreign clients in institutional arbitrations under the aegis of institutions such as ICC, SIAC, LCIA, ICA, and the DIAC, as well as in ad hoc arbitrations having seats in India and abroad. Some of the notable clients that Mr. Prakhar has advised and represented include GE T&D India Limited, Reliance Construction Infra Limited, Carrier Air Conditioning and Refrigeration Limited, AZL PLC, Fresenius Medicare Private Limited, and some of major Government of India undertakings such as IRCON International Limited and National Hydroelectric Power Corporation, that is the NHPC. Along with sir, we have Ms. Adya Joshi, who is a NUJS Kolkata graduate and has recently joined the firm's arbitration team and specializes in the field of construction arbitration. Sir, ma'am, on behalf of Team CCADR, I welcome you. And without taking any more of your time, I request you to take over. Thank you so much.
Thank you so much, Dakshita, for a warm introduction. And me and Adya are very excited for today's lecture. It brings us back to the law school to, meet the students and discuss the fundamentals of the dispute, which is the contract. So I think although the lecture today is on the arbitration claims, but I think if all of you have your bare acts with you, what we'll be today discussing would be the fundamentals of Contract Act. So essentially, just four sections which are in the array of entire disputes gamut in the construction industry today, which is around section 50 to 73. 73 is damages, 50 to 55 is the obligations of the parties. So I just wanted to thank CNLU and the ADR team for inviting us for today's lecture. And although we will try to share our experiences with you, and I will be covering the aspects of how and what my role is, because we wanted to keep this lecture in a way that the students who will be future arbitration lawyers would understand what the role of a lawyer is. And I will just give you some insights on how we prepare the case. And Adya, who has just joined our firm last year, would be giving an insight of about what she does, and that would be really helpful for all of you to understand what you are expected to do once you join the profession, especially in your first year. Adya, do you want to add something to this
Thank you so much, Prakhar. As Prakhar and Lakshya pointed out, I just graduated last year and I can't believe it's already been a year, but I've learned so much working with Prakhar and the team. And I think that's what I would just really like to share with all of you here, because I know construction arbitration can sound very daunting at first and can be quite overwhelming because it's quite technical and very voluminous in nature. So today I just want to ease all of you, put you at ease, and try and explain to you how to tackle such arbitrations and how to maximize your learning opportunities from the same. So I'll be dealing with that.
Thanks a lot. Thanks a lot. So I welcome all the students and other members of CNLU Patna and other law schools for the lecture today. So I'll start the lecture with a very brief introduction of, or maybe the topic. So today's topic is delay claims arising out of construction and infrastructure disputes. Now, what is an infrastructure dispute? An infrastructure dispute is a dispute which relates two parties. One is an employer and a contractor. It can be a contractor or a subcontractor. But the word here is it's an infrastructure contract. So today, what we need to understand first is what exactly is an infrastructure contract, and what kind of disputes can arise out of an infrastructure contract. So, I mean, as a layman's person, infrastructure means anything. It can be road that you see outside, the highways, or it can be large infrastructure projects like, for example, it can be a dam, it can be an oil pipeline, it can be even a port. So anything which involves an industry which deals with infrastructure of projects, like any large projects which generate business, or which really is owned by a public sector, or it can be a PPP. And then the award is given to a contractor for construction and development of that project. So that's those contracts, what we call is infrastructure project contracts. So in any infrastructure project contracts, especially when we discuss the topic, we'll talk about how in India the contracts are. In India, most of the contracts or infrastructure is owned by the government, right? So you have the highways, and NHAI is one example that it builds or it owns most of the highways in India. It's maintained by NHAI. How these business model or transactions work is, and let me know if I'm not audible or visible at any point of time, because Dakshita, I can't see you properly because there is some screen which is frozen. So please let me know on our chat box. So how these infrastructure contracts work. Now, in any infrastructure contract, there is someone which is called as an employer or a principal employer or the owner. For today, suppose I am Government of India and I want to build a dam in the state of, say, Jammu and Kashmir. What will I do? I will first issue a bid. I will invite bids from various contractors. So under the Contract Act, if you have read Section 2, which talks about invitation to offer. So first, you invite the contractors to give you an offer to bid for a project. How this bidding is done is it's done on a competitive basis. So an employer or the owner invites bids. That once the bids are invited, various contractors or the stakeholders who want to be part of that project, who want to construct the project or who want to develop that project, they submit their bids, which is an offer under the contract. Now that offer can be negotiated at times because of the pricing and all, and mostly these are competitive offers. So whosoever bids the lowest and whosoever has the best technical bid. So it is not the cheapest or the most reasonably priced contractor which is chosen. Usually in these cases, government sets out or an employer sets out various criteria that, for example, if you want to build a road, then you should have an experience of building roads in India. Suppose you want to build a dam, you should have built X number of dams in India. You should have various experiences. It's like you are selecting a bidder on the basis of their experience. Then there are various undertakings in such agreements that the employer expects the bidder to see and understand before sending its offer. For example, in most of these contracts, the bidder is expected or the contractor is expected to, visit the site, conduct its due diligence regarding what is the site availability, conduct the due diligence on what is the law and order situation there, conduct a due diligence upon what kind of resources it will require. Then also then after that, once these conditions, so when a bid is given, that is something which is called as notice to tenders. I mean, it's a technical term, but you must have read all these things in newspaper or in your course that tender is given. And before a tender is given, it is a notice and it has all the conditions. So basically a tender or the notice inviting bids contains all the conditions that what the contractor has to first see before entering into the contract. And once the contract is executed, what is the expectation of the contractor in that project? So I'm sure you must have read about in contracts about something which is called as, if you have been interning or if you have been reading a lot, general conditions of contract or special conditions of contract. So these are the conditions precedent which the parties have to agree before. Like suppose I give you an offer today that Dakshita, this is something you have to do and you have to do it in within 10 days. So that is like within the offer, I'm giving you my terms and conditions. It's a normal in the common parlance, it's how the contract is negotiated. It's the terms and conditions. All of us sign up for these terms and conditions in every form. You download an app from mobile, you sign up for these terms and conditions. It can be anything. But for these infrastructure and large contracts, these terms and conditions can run into pages. For example, we have been doing an arbitration where there are 4 volumes of contract documents. There is a general condition, there's a special condition, then there are overall contract conditions. So when a contractor enters into a contract, such contracts, the contractor is expected to read these conditions, uh, qualify the technical criteria and the financial criteria, and after that, the contract is executed between the parties. So for any infrastructure project, I mean, even if not for as a disputes lawyer, so tomorrow, if you want to become a projects lawyer, if you want to become a project finance lawyer, you should be very well aware that in any typical contract of infrastructure or a large, construction contract, you will have multiple conditions. And there are a lot of declarations in these contracts that, yes, I have seen the site. Yes, I have done my due diligence. Yes, I'm aware of the topography of the site. Yes, and then these contracts also divide various obligations between the parties. So, for example, if I am an employer, I may have a different set of obligations under the contract because, being an employer, what can I do? What I have to do? I have to give you, suppose you have to construct a house for me. I have to give you a land, or in some cases, I have to give you money also that, I'm going to pay you this money for construction in phases. And so it depends on contracts, how contracts are formed, and different contracts may have different modalities. But largely, there are 2 kinds of infrastructure contracts. One is something which you may have heard a lot of times is called a turnkey contract. And the other kind of contract can be a non-turnkey contract. So what is a turnkey contract? That today, as an employer, I want to build an airport. And, I invite the contractors and I invite bids from various contractors. And so all I have to do is I have to give you a land that, you build your airport, you decide how the runway is going to be, how many number of runways I can have and all. You decide everything. Turnkey means I will, on the day of opening, I'll just cut the ribbon. Then there are second type of contracts which are non-turnkey, where employer gives specifications. For example, if employer wants a particular kind of bridge to be built, so employer may give specification that this is the design that I want to build. This is I have the designs with me. I will tell you what to do, but you are the executor of the contract. As mean in this case, the architect is the employer, but engineer is the contractor. So there are 2 kinds of contract. So, but the difference is in a turnkey contract, the entire responsibility of planning, execution, everything is of the contractor. And on all these infrastructure contracts, you may have multiple subcontractors. For example, if today you have to build some tunnel, and we have been doing some arbitrations, so there are various specialized machines which have to be brought in from abroad for the tunnel construction. If it is a turnkey contract, then I can say that you arrange everyone. I'm just going to pay you as a main contractor or a leader of a consortium. However, in a non-key contract, a turnkey contract, there can be various multiple contracts with the employer and the subcontractors. So this is how the contractual relationship turns out to be. Primarily, there is an employer and there is a contractor which enters into a relationship for a development of project. Now, what happens in these projects is that employer is, I can say today that I want a house, I want an airport or a dam to be built in 5 years. Now let the contractor give me details how they are going to do it in 60 days, 60 months or 5 years. So that is how the contractor plans the project. If the employer says, I want this in 2 years, then the amount of machinery, the amount of shifts, the amount of, the workers and engineers required will be different. So initially in every contract, there is an understanding that how much time is to be spent on this project, because accordingly with that time period the contractor is going to prepare its bids. It is going to budget. If today, for example, you have to build a house for me and I want that house in 1 month, the amount of resources and machinery required to build a house in 1 month will be very different for a house which is to be built in 1 year, and the costing will change. So accordingly, how the contract budgets these kind of contracts and the development over 3 4 years is based on the timeline provided. Now what happens is that after once the contract is made aware that you have to build these kind of infrastructure projects in 3 years, 4 years, 5 years, according to that the contractor submits a plan which is a schedule. In industry terms, what we call it is something which is called as a construction schedule. It is like a chart. I mean, it's like a timetable. Basically, I would say it is like a action plan where the contractors say that today, if it is like from somebody has to start from 1st September, then contractor will come on the site on 1st September. It will, prepare, mobilize the resources by mid of September. Then every project has milestones. So if today you have to, again, and any example of a large infrastructure project, if today you have to build a road, you can't build that road in 1 day, right? What you do is you divide that road, say of 100 kilometers, into several parts, maybe 10 kilometers, 10 kilometers of block. So the contractor's schedule would be like, I will complete first 10 kilometers by every month, I'll complete 10 kilometers. So their construction schedule would be by end of September, 10 kilometers, end of October, November, and any project will have milestones. So what is decided between the parties when they enter into a contract is what is the start date and what is the end date and what is the construction program or planning that the contractor is expected to. Now, as usual, in India or in any in terms of how the conditions are, these contracts get delayed. So just a second. I'll just share some slides with you. Yeah. This is math. So in any case, what happens at times is that, these construction, all these projects get delayed due to some reason or the other. Now, what is the main reason for such delays is something which is very important for us to understand. Now, what is a delay? Delay is an event where your planning is disrupted. Like suppose that contractor had to do something in October, the floods came. What if there is flood which was more than expected rain? Then the whole schedule gets disrupted. Now, once that disruption takes place, ideally, what is the consequence of it? That whatever work that person had to do on that day, it gets stopped. For such delays and for such hindrances, usually the contract provides something which is called as extension of time. Now, if you open your Contract Act, section 50 to 55 is a chapter which deals with these subjects, which is called as time for performance of a contract. Right now, what happens is that at times where there is a delay which takes place, then there are two options which either the parties have. As an employer, I can say that no, I want this thing to be built in this years. You please leave, or I'll terminate the contract. But there are cases where the contract itself between the parties, because all these contracts envisage that there can be a disruption event which may take place. So, for example, COVID was the biggest event of a force majeure event which has taken place in the last 2 years. There are many contracts which were so derailed because of the lockdowns and all. There was you can't transport anything, the workers are not available. So these are force majeure events. These are something which you know which is called as act of God. Now, what happens is once the contracts get delayed because of such events, the contract usually provides a provision where the contractor can apply for extension of time. Now, the extension of time can be how it is done is usually the contractors. Usually in all these contracts, there's a standard provision that you please tell me how your work has been hampered by the hindrance, and accordingly the engineer or the employer will decide whether the hindrance was valid or not, and accordingly the extension of time would be given to you. Now there are certain contracts, I'm sure you must have read something which is called as time is the essence of contract. Now what that means is that if I have to do that work in 1 year, then I can't get it on the next day. You must have read that illustration in the contract act. There's the that the artist had to perform in a theater on particular day, and if she does not show up, that means your time is the essence. You can't have the performance next day. Similarly, for these contracts, if it's a time bound contract, then the contract also has the options of what should be the remedy or what should be the consequence of such delay. So usually in such cases, engineer can extend the time. And if it is a contract which is to be completed in like 4 years or 10 years or 5 years, in such cases, what even the provision comes is that we will extend the time, but for in between your minor milestone, and you can accelerate your performance and complete the project in time later on, so final date won't change. Now, although I have some problem with the slide, so I'm not able to show it, but I can just tell you in all these contracts, there are three kinds of delays which take place. So first we understood what the infrastructure contract is. It is a contract between the parties where a contractor has agreed to complete something within certain time frame, right? And for that, the contractor is going to get payment. And so I'll just come to how the payments are made. Now there are two kinds. There are two ways you can make the payment. One is you can pay it on a lump sum basis. That today I'm going to give you 1 crore to build a house. You build that house in 1 crore, and I'll not pay you any extra rupee for that. Second is, I'm sure you must have seen how these all a lot of builders build the apartments and all, that they take money in phases. What they do is that today they say that it's called something which is called as item rate contract, where or the payment is to be made as per the work done. Today how these contracts work is that the contractors performs the work, so it usually takes an advance from the employer for say for 1 month, and it will perform the work, and after at the end of every month the contractor will raise a bill that I have done so and so work in 1 month. For example, if I have to build a road, I have built 1 kilometer of road in a month. So whatever money I have spent in 1 kilometer of building of road, you please pay it to me. And usually these are progressive contracts where the money is paid in every month based on the work done. Now, what happens is that this all planning and all is done, as I said, for a particular time bound contract for 5 years or 4 years or whatever is mentioned in the contract. Now, when there is a disruption event, that disruption event causes a delay, and this delay results in shifting of dates or shifting of something which is called as the workflow. Now, if today, for example, I have to build a road and there is a floods, and the area is washed away, my planning was that I'll complete that road maybe by next year, that highway next year. But uh, if I have to complete that highway say next month, and suddenly there are floods, then what will happen is my machinery, my workers will remain on site, and I have to pay their salaries also. Now, what will happen is I will ask an extension from the employer saying that I need some more time. Now again, the contract may have two conditions. Because of a hindrance, there can be a time given to you, and whatever, sometimes the contracts also contains a provision where I will pay that extension plus some money will be compensated to the contractors, right? Because that it has resulted in some delay and extra money spent on resources, but that is something which is agreed by the parties. So when it comes to delay, there are three kinds of delays, which I'm sure all of us have understood and read in a contract scenario. There can be a delay because of the employer, like A and B enter into a contract. There can be a delay because of A, and there can be a delay because of B, and there can be a C type, which is an act of God, is a force majeure event where none of them are responsible. Now, in all these infrastructure contracts or any contract for say, what is the now what is let us understand what is an obligation of a employer. Now, what contractor usually tells, and once you start practicing, you will get these standard types of claims. Suppose if you're representing an employer, and you must have seen this, it's always in the news that suppose a national highway is being built, there are the encroachments on land. So they say that land was never handed over to us. How can we build a highway? So the contractor claims that, okay, you handed over the land, but you did not take over the land on time. There were encroachments, there were some railway line which is going through, there are houses, people are agitating. We can't build a road. As simple as that. So handing over of land is something which is in every road construction or any contract which involves, maybe I was doing a arbitration for oil pipeline construction where the villagers started intervention or agitating that you can't build a pipeline because you have not paid me the compensation. So a contractor will always make such certain these kinds of claims that the employer has not given me the land. Second type of delay which can be attributed to the employer in such cases is that you have not given me the specification. Today you want to build a dam, but you have not given me a drawing as to, where do you want to put this place, or where, like, in large contracts, I'm just telling in a very layman's language, but there are very complex terms like coordinates. Today you have to build something, and if you're building such a huge structure, there has to be an accuracy of what is to be built where. So if the employer is not giving the proper drawings or proper, as I said, architect, proper, specifications that how do you want to build, then there can be a delay. Now, majorly, these are the kinds of delays which are usually attributed to the employer. There are third kind of delays because being an employer, I have to take permission. For example, if today I have to build a building near or a high-rise apartment near airport, I have to seek approval from Airport Authority of India, or I have to seek approval from the airport. Now, if the employer does not, or the landowner does not take that approval, builder can't construct. So builder will say, okay, I am on site, I have everything, but you have not taken an approval of the Ministry of Civil Aviation, or it can be an environmental approval. Suppose it involves cutting of trees on the highway. So these are the delays which usually a contractor uh, alleges that these are employer's delay, right? As an employer or the owner of the project. Then there are second kind of delays which is usually attributed to the contractor. Now, this can be that a contractor did not mobilize on time. So today, if I say that you have to start a project on September and from 1st September, but you don't have your machinery on the site, you have not mobilized your resources on site. So there's a delay in mobilization. It happens at times that the contractor is unable to mobilize. Sometimes they have to bring specialized machinery, cranes and all. They don't do it. Second kind of delay, what usually contractor is attributed to is delay your breakdown of machinery, proper machinery is not there, old machinery, there is no proper technical people, manpower is not, workers are not there. And why I'm telling you all this is, suppose today, tomorrow you start working on an arbitration, and suppose a contractor has a claim against you. So how we build up a case is that whenever a case comes to us, we have to read all the correspondences. So a contractor can say n number of things that, okay, you did not give me the permission to build the building, so it is your fault. But if you read the inter-se communication between the parties and you find out that the contractor was not even mobilized on site, so the initial delay was not because of not taking the permission. The Before taking the permission, the contractor had to be on site. So this is how we build the case. So whenever the case comes to us, we ask our client that you please send us all the communication that has happened between the contractor and the employer. And then how we do is we divide that correspondence or communication into various heads. And usually this communication can run into 30, 40,000, 50,000 pages as well, because sometimes the by the time the claims or the dispute start, it is already 3, 4 years into the contract. It never happens that the contractor starts the project and the dispute comes. Usually because the amount of money which is involved and arbitrations uh, all these arbitrations are usually of 100 crores, 500 crores, 1000 crores claims. So the way these dispute arises after a gap of 3 years, at least because of the limitation period, you have to file your claims. So the correspondence of 3, 4 years accumulates over the time. And so our first job is to first understand what this communication is. So we divide the communication, all of us sit together, we read mostly, we read letter by letter, and then we divide these letters into various heads. Now, why I was telling about the delay events are that as an arbitration lawyer or as any trial lawyer, how you divide these matters is, how you divide this communication is, you divide in various blocks. Okay, delays alleged by the contractor, there can be 10 types of delays. So you read 10 letters, one letter may say land not available, second letter may say you have not taken approval, third letter may say some XYZ. So you divide these letters into various categories. Then you may come across the responses to these letters. So if the contractor is saying road not there, then there might be a letter from the employer, no, road was given on X day. So that there's a cutoff period for that delay. Then we read letters from our side, or maybe you are representing contractor or the employer. That employer also may say, okay, you don't have machinery. So this is a lot of, in every such dispute, there's a lot of to and fro communication. One alleges on the other, it's my word against your word. And in the end, the arbitral tribunal or the court has to decide who is right. But in order to prepare for that hearing, you first need to understand the heads of delays. As I said, you need to segregate the documentation into various parts at who is causing what delay. Then there can be a force majeure event that, it's an act of God. I can't do anything. You can't do anything. If there is a flood, I'm not responsible for it. So no one is responsible for it. Once you divide all these delay events into various categories, then you see what is the consequence of it. Now, if you see section, you must all of you must have read section 73. Now, section 73 talks about a consequence of a breach, right? If A and B enter into a contract and A breaches that contract, then B is entitled to a loss or a damage arising out of that breach. So if today, Dakshita, if you are the employer, if you had to provide me land, and if you don't provide me land, and if I am delayed, my project is delayed, then I will say you are responsible because you breached your obligations under the contract. Now, this is how, so for example, in arbitration, as I said, what kind of claims can come through? What can happen is that the contractor may file a claim for extension of time saying that, my 2 years is wasted because of COVID. I want 2 years of extension. The employer may say, no, 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 the lockdown was only for limited period. It was lifted on 31st May 2020. After that, you had to start working. You can't claim for like 1 year. Then, for example, the contractor sought like 1 year of extension because of COVID. The employer may give 5 months of extension, which is the actual lockdown period. Then the matter goes into the dispute. Then the tribunal decides whether the work was able to take place during non-COVID period, and whether there was an opportunity for the contractor to work or not. If there was no restriction by the government, then the contractor is responsible for not mitigating its losses or not acting upon diligently. So these are the claims which can come before an arbitral tribunal or an arbitrator that decide the time of delay, like maybe 1 year or maybe get a declaration that yes, contractor was entitled for 1 year or seek extension of time. Usually these cases are in these contracts, the claims are first filed before the engineer, and once then it is amicably settled, and after that the tribunal adjudicate these disputes. Now, the second leg of uh, you know claims which may arise out of a delay event can be a can be a cost claim. Now, what is a cost claim? Today, there is a disruption event which has taken place, which has resulted in delay of a project. Now, what has happened? It can be anything. The delay can be of anything. Now, what may happen is you have budgeted your resources, machinery, and everything for say 5 years. Now, it has happened at times that the project which has to be completed in 5 years, it gets 10 years to complete. Now, what happens is that if it takes 10 years to complete, that additional 5 years is something which the contractor never envisaged at the time of bidding. So what the contractor says is that I want extra money for this. What is this extra money? The extra money, either it can be contractual. At times, the contract provides that if there is a delay, then the money can be given to you. Sometimes the contract is silent on it. Now, what usually the contractors do is they allege that since you breach the contract, since you breach the reciprocal obligations, which is something which is given in section 51 of the Contract Act, which is, you breached the contract. I am now entitled for damages for that breach under section 73 of the Contract Act. So that is how these, claims are formulated. Now, what happens is once you claim damages, now the question comes, what kind of money claim the contractor may have, right? Now, if you have interned previously with any arbitration team, or you have generally worked on a moot court or something, you may have heard terms like prolongation claim. You have heard terms like idling claim or maybe underutilization claim. Now, they seem complex, but I'll just explain these all. These are the three terms which you will hear in any disruption claim or any delay claim. These are the three cost claims which arise. The first type of claim is a claim for prolongation. That means if the contract was for say 5 years and it took like 7 years or 10 years to complete, then the contractor had to remain on site for extra 5 years. Now, for the extra 5 years, it can get the money for the work it is doing, but it did not budget the extra 5 years it may have to spend. So what it will do is it will claim cost for prolongation. How you claim cost for prolongation is that I paid, contractor paid salaries to its workers, contractor had to maintain the machinery at site. Suppose at times happens is contractor hires a machine on rent for some work, and according to them this will be done in 5 years and they will send back the machines, but what happens is it has to stay site beyond the original duration. It can be of anything. I mean, there are many projects, if you read in the news, they are delayed by years and years. What happens is they have claims. There are many highways, I mean, the many examples of it. So this is called something which is a prolongation claim, that I stayed there beyond the time. And why did I and at times in these cases what happens is that the work is say disrupted intermittently in between, like 1 day, 2 day, 3 day. There's never a long period of gap. It's like something happened or the other, or maybe it's sometimes the contractors allege that I anticipated that this whatever information you gave it to me was this, but when I started working, there was a different terrain. It was a harsh terrain. It took more time than expected. So, I want a prolongation cost for my resources which I have spent. This is the kind of claim which the contractor allege. But please understand, for these claim, if there is no understanding between the parties under the contract, then under 73 the contractor has to prove that the delay or the hindrance or breach is on part of the employer or the owner. Otherwise, why should I pay someone for delayed work if it is not my fault, right? Now, the second kind of money claims which may arise out of these disputes is a claim for idling. What is idling? Idling means someone doing nothing, right? It's idle resource. Now, what happens is we are doing a matter where there was a construction of a large project and the project was stayed by National Green Tribunal. So what happens is that, the project shuts for 2 years till the time the matter was going on in the NGT or the Supreme Court or wherever, different forums. The project has been stayed. I'll give you the biggest example. I mean, if is about this place called Lavasa near Pune. It was built and there was some environmental non-compliances. The project was stayed by the government and it was stayed for around 7-8 years. So what happens is when there is an issue which arises that there is a idling of, so if the project is work is completely stopped, then what is the option available with the contractor? Either it can send back the machines or it can remain idle, like it is doing nothing. And maybe at times there are floods and there are many various factors where there is intermittent idling of work. Then there is an idling claim. So the contractor says that yes, I have been working, but this idling is not because of me. It can be because of you. Because suppose you did not give me land, I was ready with my machines and people. You did not give me the land, so I was staying idle for like 4 months initially, even after mobilizing at site. So you give me money for maybe the rent of my machines or salary of my resources because I actually started working after 4 months. This happens in cases where the contractor comes on site, but the employer does not hand over the land or the site for which it has to start the work. Then there is a third kind of money claim which we have started, we have seen in many arbitrations, which is something which is called as underutilization. Now, what is an underutilization? It is a very fancy word of saying that I am slow, but I can't underutilize my resources. I have been working tirelessly for something, but I am unable to finish it on time, or uh, there are hindrances which occur on site. Because of it, it is delayed. So my resources are underutilized. If I can work 8 hours a day, my machine can work 8 hours a day, but it is only working for 5 hours. So 3 hours is getting wasted. So I am not able to generate the money because, as I told you earlier, that these contracts, how they are done is that contractor only gets paid what they work for. So if today I am a lawyer, suppose I get money to work on an hourly basis, and if I can work for 8 hours and I can only now work for 5 hours, then I'm not able to generate money for next 3 hours. Similarly, the contractor would say that, I have my machines to work for, say, 8-hour shift or 10-hour shift, but I'm not able to do it. So you pay me, compensate me for underutilization of my machines. This is third kind of a claim which you get. Now, in order to prove these claims, as I said, that the breach has to be proven. And if there are something which is called the force majeure claims, where if a contractor may say that if it is something in the contract that for force majeure, who is going to bear the cost, then there are many cases which are change in law. Like today, if there are a lot of cases where the GST was introduced, the tax rate changed. So who is going to bear the cost of the taxes which is levied, which is extra? So the contractor are usually, these contracts are so sophisticated that they envisage every possibility of who of these events. And if it is not envisaged, then we follow the Indian Contract Act, and then accordingly we decide how these claims are to be adjudicated. And then this is how the planning is done. I mean, although I spoke a lot about how the kind of claims you get in these contracts, but as a lawyer, the planning, what starts is that we start, I mean, Adya would be explaining to you what are the checklist as an arbitration lawyer, especially as an associate, and what the work you do. But how we analyze every dispute is that first we read, we understand the whole contract, because as I said, a contract may envisage everything. A contractor or the employer may say anything, but ultimately the tribunal or the arbitrator has to decide what is in the contract, because in the end an arbitrator or tribunal is a creature of a contract itself, so it can't go beyond the terms of the contract. Because even if today me and you decide that if there is a lockdown situation, you will still keep paying my salary. If there is a contract between us, then yes, the contractor has to the employer has to abide by it. Similarly, so at the end of the day, what we do is we read the contract, we divide it as per the heads of various delays and allegations, and then we proceed with the case. Now I'll just hand over to Adya, who would be explaining to you. I mean, I've just given you a very brief overview of what these claims are. She would be telling you what exactly a role of a first year or a fresher lawyer, which most of you would be in some time, is in such disputes. So thank you so much. At the end of the session or the lecture, we'll take up some question and answers. So thank you so much. I'll take your leave and I'll give it to Adya.
Hello. Hi. Am I audible and visible? Yeah, I think I am, right? Dakshita, yeah. All right. So, hi once again, everyone. Like Dakshita and Prakhar said, my name is Adya Joshi, and I've been working at SAM ever since I graduated last year from NHS Kolkata. Now, Prakhar has given you an extremely informative session, and I think by now you've all understood what construction arbitration entails. But like I said from the beginning, I'm sure it can be slightly overwhelming for everyone right at the start. As Prakhar explained himself, these sort of arbitrations are extremely technical and voluminous in nature. To give you my own example, the first arbitration I ever worked on, the documentation which the other side filed was around 45,000 pages. And as that being my first arbitration, it honestly felt quite daunting. But what I soon realized is that once you detangle all the technical jargon and all the mumbo jumbo, at the end of the day, like Prakhar said, there are just some basic legal principles which we all learn about in our first year: contract law, limitation, etc. To give you another example, we were just recently doing an arbitration regarding a tender project for a solar project. Now, I don't know what a solar project is. I'm not an engineer. I've never learned what are the specifications. But while actually sifting through the documents, we realized that the actual crux of the dispute was just about basic principles of offer, acceptance, conditional offer, conditional acceptance, something we've all learned time and time again. So what we need to realize is just about applying these same basic fundamental legal principles to slightly, I agree, convoluted and complicated fact scenarios. So in order to explain how exactly we go through an arbitration, I'll just be sharing a small PPT. Just let me know if it's all visible.
It's visible, ma'am.
Okay, thank you. So to understand one's role as an associate, first we just need to understand the basic stages of an arbitral proceeding. So it starts with the pleading stage, and that is after the notice invoking arbitration is then the arbitral tribunal has been constituted. we file our statement of claim, our statement of defense, rejoinder, surrejoinder, etc. After all pleadings are completed, it goes on to the stage of the points for determination or issue. That's when the tribunal sifts through all the proceedings and based on consensus of both parties, we decide what are the main issues to be decided. Third is the stage of evidence. Honestly, my favorite stage, the most interesting and the most fun. Like practically speaking, it's the most fun stage. And this is the stage in where you have your witnesses. Your witnesses are there, they are cross-examined, you give your evidence, and it's a lot of fun to actually witness this in real life. Lastly, then we'll have our final argument stage in which both parties make their final submissions. And afterwards, there's a stage of usually written submissions in which you summarize everything that has been said, and the tribunal goes through that before making the award. Now, this just keeping in mind these basic stages really help one know what is required at each point of time. Now let's start with drafting pleadings. Now this may sound cliched, but of course the most important thing is to read, read, and read. If you don't like reading, I'm very sorry. This is probably not the best area of law, but it's all about reading and familiarizing yourself with all the documentation. This is especially important for a first year. You will have your senior colleagues, like for example, I have Prakhar and my other senior colleagues who will do the main strategizing in a case. But as a first year, it's up to you to be on top of all the documentation, try and collate and understand everything to the best of your ability. And for this purpose, lists are really, really good. It's always great to have a list of dates, a list of documents, a list of letters, a list of important contract clauses. Not only is it easy for you, therefore, to try and simplify and understand, but it's also very helpful for your arguing counsel or for the team in general. Like as Prakar was speaking about earlier, usually there's a lot of correspondence. So what we do is we have a list of letters. We try and divide these letters belong to like these are to delay events, these are for cost claims, and all of this is therefore extremely helpful. So make lists your best friend. I'm sure as interns you've all done this. I was doing this till last year. You've been asked to make list of dates, list of documents, and you think it's a very tedious process. It is tedious, but you will be so grateful afterwards because this will help you so much. Apart from that, the contract. Now, the contract in whatever dispute you have is the most important document. And I would suggest that all of you read it thoroughly and carefully and try and actually understand, therefore, the complete contractual understanding as a whole. In these infrastructure projects, now there's something called a FIDIC. So FIDIC is the Federation of International Consultants and Engineers. Now, what FIDIC, the body, does is it gives international standards for contract templates. And these templates are adopted almost universally throughout the world. So all your infrastructure and project contracts are usually based on this same model, the FIDIC model. And how the FIDIC model is divided is the FIDIC gives you some general conditions of contract. So that's your basic standard template. And what parties do is they adopt certain FIDIC clauses into their own fact scenario. And these are called the conditions of particular application or COPA. So these terms are something you should get familiar with as you will come across this in all proceedings, the GCC and the COPA. And it's very important to understand these clauses. And a helpful tip for you guys is because, like I said, FIDIC appears in almost all of these construction arbitrations, is that FIDIC has FAQs, which are available online, which give you standard interpretations of certain clauses. For example, if your dispute is about extension of time, usually there's a clause 44 in the GCC, which talks about this. So you can go online and try and understand what the standard interpretation is. These things are very helpful. And if you stay on top of these things, you really help yourself and the team in general. Another point is that I would suggest is always do a little bit background research as to the project you're doing. For example, if you're doing a dam project, sometimes you just Google parts of a dam so you can visualize the project. Why this is important is, for example, there's a dispute happening about whether about an extended causeway. Now, what is an extended causeway? Or a spillway. If you don't understand what that is, it's very hard to understand what the arguments are about. For example, a lot of delay claims are saying that we were working on one part of the dam, hence it was not possible for us to do work on the other part of the dam. If you actually have the dam in front of you, the picture, you can actually understand maybe it was possible to do work on both parts at the same time, and maybe the other party is exaggerating their claim. So it's really great like this if you try and just get a basic understanding. You don't have to be engineers, of course, we are all lawyers, but just a basic understanding really helps you. But like I said, even though you should get a basic understanding, we are all lawyers, we are not engineers. So please feel free always, if they're very highly technical points, sometimes it's actually good to clarify points with your client, because these are very technical arbitrations. Clarify them with your seniors, your client, because like I said, it can be complex. So don't feel that overwhelmed as well. That being said, while actually drafting, just keep language as simple and concise as possible. You see, the tribunal may not always be comprised of technical experts as well. Just sorry. Yeah, so tribunal may not comprise of technical experts as well. Excuse me, sorry. And for them, it's as complex as it is for you in understanding. So you also have to think about it in that sense. How can I break these technical points and explain it from a layman's point of view? And in fact, bombarding the client, bombarding the tribunal with a lot of this jargon may be detrimental to your case. And this is something which we face practically a lot. Clients are often very passionate about their cases. They know the in and out. They know that this permeation grouting was supposed to happen to 4.5 inches, but it only happened to 4.4 inches, and that's a huge deal. And they get very passionate about it. And sometimes they like, no, no, you have to argue this, please argue this. It's your job then to try and explain to the client and try and put the client's point across in a much simpler way to the tribunal so that they also don't get confused. Of course, one thing is extremely important while drafting. I said read, read, read. You also must proofread, proofread, and proofread. It's very important. These, of course, basic drafting skills. So I'm not going to go much into this, but you should know these things, especially when you have voluminous documents and statements of claim defense, which go into hundreds and hundreds of pages. It's very important to keep like proofreading, reviewing, taking a step back and looking at things holistically. Yes, okay. So the next stage is the evidence stage. Like I said, my favorite stage, because there's a lot of fun you have in this. Now, at this stage is where you bring out your witnesses. And in construction arbitrations especially, it's great to have a lot of technical and expert witnesses. The point being is, if you bring, for example, you're having a project, a dam construction project, right? And you can bring in like the head of the project, if it's a government entity, the CEO or the MD, whoever, they might be able to give you a general overview, but the actual crux of the dispute will be what happened at the ground level. What was that engineer or that worker in charge? Why did they give a certain? Why did they say a certain work could not be performed? Or how did they compute certain costs which they awarded to the contractor? For this, it's very important, especially for quantification, to have technical and expert witnesses. But the best combination, of course, is to have a variety. Different types of witnesses, and drafting their evidence is also a very key stage. You see, this is again a practical point. You often work with engineers or certain workers and all who are very well versed in their technical domain, and they have great domain knowledge, but they might not be able to translate that in language which, like I said, it is simple for the arbitral tribunal to understand. So that's where your role comes in. It's for you to try and translate all of their points and put it in a simplified manner so that they can testify for the same. Another thing which you should remember is that it's very, very important that you should make sure that anything a witness is saying or putting down in his or her affidavit should be able to be traced back to some form of document or evidence. Often, like I said, like a client or an engineer will be like, yeah, they said this and they promised this, but they didn't do this. They told us they will be giving these machines to us and they didn't. That's all well and good, and they are probably right as well. But unless you can trace it back to some sort of document, it becomes very hard to prove. And in cross-examination, it can therefore reduce your credibility. So this is something you should definitely look out for as well. Apart from that, witness affidavits should generally be used to your advantage. The greatest asset is that whenever there are any gaps in your pleadings, you can utilize these. You can utilize witnesses and experts to make sure you plug in any gaps in this zone. All right. Sorry. Just give me a second. Sorry, I think it got slightly stuck. Yeah. The next stage. I'm so sorry. I'm not projected properly, but I think you can all still see it. Yeah. So the next stage, after all evidence is closed, all your pleadings have been submitted, is your arguments, which are your final arguments. Now, this is very important stage for an associate because by now you should know the contract by the back of your hand, you should know your documentation, you should know where everything is. And now is the stage where you start making convenience compilations. These are very important both for the tribunal and for the arguing counsel because it's a construction arbitration, because it's so complex. Now, what parties tend to do is they en masse dump thousands and thousands of documents. But actually, while pleading, you're not going to rely on every single one of these letters or every single invoice or anything like that. So, what you do at this stage is you make compilations of just what are the relevant documents that are fundamental to your case. And usually, what we do is this we file this before the tribunal. We also have it internally for your arguing counsel to rely on as well. And this becomes extremely important. Of course, it's important in other arbitrations and proceedings as well, but very, very important here because you realize the tribunal also, they are also going to be tied 6 hours arguments. They're going to be okay, first go to this volume of a volume 100 page 4005. It's too much for them. For that purpose, it's really great to have a convenience compilation. Same thing for notes. It's very good to have notes, like just a note on certain case laws, notes on distinguishing case laws of the other side, brief contract clauses, things like that. As an associate, and I'm talking about like what my job is to get these notes ready so it's easier for everyone else to argue. All right. Now, one thing is about anticipating everything. I'm sure you all know about Murphy's Law, that if whatever you think will go wrong, apart from that, 50 other things will go wrong as well. And that always happens. No matter how prepared you think you are, something or the other always goes wrong. You should always make sure that you have everything in place. I'll give you a small anecdote. There was an arbitration proceeding that we were attending. Final arguments were going on, and one of the counsels asked for an arbitration act. Now, would you believe with an entire arbitration proceeding, not one member of the arbitral tribunal or from the other side, 6 lawyers, our side, 6 lawyers, not one person had an arbitration act. It was slightly, and so these are the things you need to try and avoid and stay on top of everything because your role is mainly to try and help, assist, and make the life of your senior counsels, your senior colleagues, and your arguing counsels life easier. That's why I say due diligence is not just for GC. Like I'm sure if you have friends or like seniors who are working in GC teams, they're talking about how they're doing DDs all the time. Yes, we don't do DDs, but it's very important as well for us to do our due diligence as well in that sense. Another thing, just going back a little, while strategizing as well, I'm just going back to the stage, while drafting pleadings as well, something to keep in mind is strategizing with your senior colleagues as to what all would you like to file. There are different things you can do. Apart from your statement of claim, statement of defense, sometimes parties file a Section 17. Now, a Section 17 application, if you have your Arbitration Act, is for interim relief. There are two types of interim relief, very briefly. Section 9, which you can go to the court asking for interim relief for something which cannot be granted by the arbitral tribunal. And otherwise, you can go to the arbitral tribunal seeking relief. Now, sometimes parties file a Section 17 right along with their statement of claim. They want that to be decided first. These are all strategy calls which you have to take. Or sometimes what you want to do, you want to slightly delay the proceedings, you also can file a Section 16. A Section 16 application basically is challenging the jurisdiction of the arbitral tribunal to decide the matter. I think you must all be familiar with the principle of competence, that the arbitral tribunal has the jurisdiction to decide on its own jurisdiction. So that is also something the parties often take, and that becomes important in construction arbitration, is the way that these contracts are usually constructed is that there is an engineer There's an engineer in charge in respect of the project, and he or she, whenever contractor has any claims while the project is ongoing, they raise the claims with the engineer in charge. And it is the engineer in charge who determines the claim. And afterwards, that decision of the engineer is always, of course, subject and scrutiny to the jurisdiction of the arbitral tribunal. Now, often what happens is parties don't want to go to the engineer in charge. They submit it, or they feel that the engineer in charge is taking too long to decide their claim, they go straight to the arbitral tribunal. So often then parties file a section 16 application saying, but there is no, that the correct procedure has not been followed. First, let the engineer make a decision, and then it can go to the arbitral tribunal. So this is also a type of strategy call that one makes in this scenario. So these are just the general principles you can keep in mind. And like, I hope I've explained enough as to what my role and what your role would entail uh, as a fresher. I hope it was not at all overwhelming or daunting. Trust me, it's actually a lot of fun and it's so interesting because the great thing about construction arbitration is that you get to learn about so many different type of things that you wouldn't have read about before. So it's great overall experience as well. And Prakash, is there anything else you'd like to add? All right, I'm just gonna just stop sharing the screen right now. Yeah, 1 second. And I think Prakar will also now be taking questions. 1 second.
Yeah. Hi. So yeah, we are open to any questions that I think there's some problem with the camera. I don't know whether you can see us or not.
We can't see you, sir, but you are perfectly audible for us. We request all participants to please drop the questions in the chat box, and Priyanshi will read them out for our guests.
Can we just join again? Maybe there's some glitch in the camera. We'll just join
Right.
again.
Absolutely, no, not an issue. Till then, I request the participants to please drop the questions in the chat box, and we'll read them out for the guests.
Uh, yeah, there is some issue with the camera, although my camera is on, but it does not appear to me that, it's not visible. Maybe we'll just join from Adya's laptop and then we'll connect, but we are open to any questions because anyway, we have taken more time than, permitted. Yeah, tell us. Okay. It's just, there are three questions that I can, an
So,
example.
do you want me to read them out for you?
Yeah, you can just read it out to us. Yeah, we'll just join from the other laptop because that has video also. Yeah.
Right. So the first question that we have is from Akshay Panchal. Akshay asks, any example with contents related to period during COVID situation? I think we lost. Keep your questions incoming and. Okay, Akshay means claim.
Hello. Yes. There is some issue with the camera, but yeah, the mic is fine. So you can just ask us the questions. I mean, I could not hear. There was some connection break.
Right, sir. So the first question was, any example with contents related to claims during the COVID situation?
All right. So most of the claims which has come during the COVID situation, uh, in terms of time claim, yes, there are always claims which seek extension of time for the COVID. Now, typically, what we have seen is that the lockdown or which was dependent on government orders was the force majeure event. But whenever the lockdowns were lifted, at times, there are, the contractors took time to remobilize their resources, and that took more than, some time, more than many days. And there we have seen a lot of disputes because the employer is saying, no, the lockdown was for only say 30 days or 60 days. We can't give you further time relaxation. You should have preempted it and, kept your resources ready. In terms of money claims, yes, most of the claims relate to reduction, maybe waiver of rent or waiver of certain charges which the contractor or any party had to bear in a normal course of time. For example, there are a lot of malls in New Delhi or any all over India where there was a force majeure event and the parties did not pay rent, which was the monthly rent, and they asked for waiver or reduction in rent prices. So this is the kind of claims which we have so far witnessed in COVID situation. In fact, one of the arbitration we were doing is where the tenant, it was a huge tenant premise. Tenant was moving out, and before it could move out, the lockdown happened. So it could not move out its furniture and the I mean whatever the resource or the material from the office, and the landlord, which was a company which had a claim for rent till the day that money that the office material was not shifted out. So the argument was by the by the tenant that the lockdown prevented me from completing and discharge of the contract, and I should not be paying rent for till May, which is till the lockdown ended. So these are the claims which we have seen so far in terms of how COVID situation has come.
Right, sir. Thank you. Another question for you, sir. In a construction contract, generally idling claim accountable to force majeure are not compensated by the employer. For example, a project was supposed to be completed before the pandemic struck, that is a force majeure event. However, if the project has been delayed due to the default of the employer in handing over of land initially, which forced idling of resources during the force majeure event as well, can idling claim be filed for the force majeure duration in such a scenario?
So in such cases, what usually happens is that there has to be a bifurcation of disruption. So this is something which we call as delay analysis. So if there is 100-day delay, the entire delay can't be attributed because of one event, right? In your case, as I can see, the project was to be completed before the pandemic struck. However, the project has been delayed due to default of employer handing over land, which initially idling resources during force majeure. So no. So see, in this case, what happens is that initially there was a delay in handover of land. The resources were idle. Now, when the pandemic struck, even under the Contract Act, there is a principle of mitigation. So how did the contractor mitigate? If it was keeping all its resources on site, then it is not mitigating its losses. It should have ideally, returned the machines or the manpower for the time duration. And that is what the employer would say, that you have not mitigated it. You were just keeping your resources on site just to earn money out of it. So this is, it depends on how the tribunal sees it, and this is a matter of contention. But yes, this is what the employer would argue, that you could have mitigated such idling at during the lockdown time of COVID.
Thank you, sir. The next question that we have is from Mayank Kumar. The question is, what is the standard of evidence for claims of loss of future profit in case of delay?
Well, loss of profit, at times what the contractors say is that the how much they have budgeted in the contract, and usually what they do is that they keep a standard rate of 10% or 15% of the margin, which is the profit. So if I am spending 100 rupees of my input cost on a project, then it is expected at times that the contractor says that 10-15% is the component of profit. However, there are various formulas, there is to calculate such a profit component. I mean, there is Hudson formula, Emden formula. So what happens is it it calculates the input cost and on various factors, and then calculates the profit margin. So this is something which is usually done at the time of claiming such losses, and mostly we have experts or financial experts who do calculate the loss of profit in such cases, and it depends on various factors. I mean, not just one, as I told you. I mean, and the standard of evidence is usually the cost. So you say that this is my input cost, and this is my margin, and this is I could have earned as a profit, and it's mostly based on the formula and mathematical calculations. But in terms of proof, the contractor showcases its balance sheets or maybe an auditor certificate about the cost implications.
Right, sir. Thank you. The next question we have is from Palash. Palash asks, when the parties have signed and agreed any express condition written in the contract, but the conditions are not in line with the statute for illustration award, insignificant damages when a promise is broken. Initially, the contractor agrees for less damages, but later they say that actual loss is more. So in this situation, which will prevail? Damages written in agreement or damages as per the statute?
All right. So agree the express condition, but it's going to not. So now what happens is that there are two situations. If today now how in arbitration how it is perceived is that when two commercial parties enter into a contract, they enter it with open eyes. Now, even if one of the terms of the contract is onerous or less favorable to one party, does not mean that that the contract is void in nature. Now, a contract can only become void if it is against the principles as put in the contract act. So if it is an illegal contract, so today if I say that I and you enter into a contract and you will never claim damages from me, it is a contract, right? Because you are giving consent to me for that situation to arise. Now, if I'll just give you a very slightly different situation where the statute prevails. Usually what happens is that in a contract, it says that you need to claim any compensation, you need to write to the employer within say 30 days. This is a standard contract. Sometimes you read that within 30 days, you need to tell me how much money I have to pay you. Sometimes the contractor delays in giving that notice, and what happens is that the employer says no, you did not raise the claim in 30 days, I will not pay you anything. There the courts have said that the statute provides 3-year limitation period, so a contract cannot go against the statute. Now, even if you read section 73 of the contract, and most of the sections under the Indian Contract Act start with the term unless understanding is to the contrary. That means unless and until you have a contract which says that you will not get a compensation, then you will not get. So it depends on it's just like limitation of liability clause, in a contract. If you have entered that you have executed that contract, then you cannot. But yes, these clause a party can claim under section 73 if it is able to prove that that breach is not envisaged under the contract, which is a fundamental breach of contract. So yes, in such situations, party can claim more than what is awarded, and it can also take the defense of duress and one-sided plea bargaining under the contract. Yeah, I mean that is, I mean, according to me, is the response to that query. Yeah.
The next question that we have is from Bandula. She's joining us from Qatar. And the question is, in a construction contract, preliminaries shall be paid based on the time or based on work done. Contract type is lump sum.
See, I mean, I've not been able to understand the question to the fullest, but what I understand is that, as I said, there are two kinds of contracts. Either you can have a lump sum contract where I pay you money upfront, or I pay you money upon completion, that yes, I will pay this much money for the entire work. Loss or profit is your your job, the contractor's job. Or I can have a contract where I will pay you for the work you do. So there, it's something which is called as, in on an every interval, how much work you do, I pay you on that. So I mean, that is how the contracts are for two kinds. And preliminaries, and sometimes the contractor is paid advance. For initial work, you don't have money. So I will pay you mobilization advance, or advance to start the work. Once you start working, then you start raising the bill, then the cash flow system works, and then how the contractor is paid till the completion of the contract. Yes. I
Right,
think
sir.
I think there's question from Suryansh.
Right.
I think that is the next question. May third parties obtain right under construction contracts? How will now, in such cases, usually a party, if I as an employer enter into a contract with the contractor, then a contractor may have several subcontractors on board, but the subcontractor can't really directly claim money from the principal. So this is something which, usually all these contracts have the checks and balances, because the owner is, or the main principal is dealing with the subcontractor. And if there is a relationship, yes, otherwise, usually the contracts have this wall between the contractor and the subcontractor. Subcontractor has to raise it claim with the contractor itself. There can be a back-to-back agreement situation where the contractor again, raises claims with the employer, stating that the subcontractor has such claims and you are, liable to compensate it. So yes, in such situations, otherwise directly it may not. Yeah.
So our final question is from Monte Carlo. Is contractor entitled to cost compensation in case of concurrent delays?
See, in such cases, the delays are because of both the parties. Now, what would happen is, even in such cases, usually not. I mean, this is what the employer would say, that since, if, as I give you an example, if you are causing, I'm responsible for certain delay, and at the same time, the contractor is causing the delay, and because of that, the delay is concurrent. So employer would say that it is not my breach. If I did not perform that obligation, still the contractor's delay would remain. So in that situation, it is not entitled to any compensation, provided if there is a scenario under the contract which says that, even otherwise for any delay, some compensation would be given to the contractor for the time duration of the hindrance. So yeah.
Right, sir. Thank you so much for dealing with all the questions. I don't think that there are any more questions from our participants' end. So with that, I believe we have taken too much time of our learned guests today. I would like to take a moment to thank everybody for joining in and making this guest lecture as interactive as it was. On behalf of Team CCADR, I would like to extend my heartfelt gratitude and thank Mr. Prakhar sir and Ms. Joshi ma'am for taking out time from what we know is a very busy schedule and for sharing with us the practicalities that are not taught in law schools and can only be learned through experience. Thank you, sir. Thank you, ma'am. We can't see you, but we know that you're there
There
with
is
us.
some issue with the mic, with the camera. So unfortunately, we are not visible, but we are very thankful to CNLU and the CADR team for inviting us today. And it was a very good learning experience. And we're very, I mean, glad to share our experiences. And we were also glad that, this all the students had, and everyone listened it so thoroughly, and then and you all had very genuine questions, and we'll be always happy to host any other session later in the future. uh,
Yeah, thank you so much. I think Prakhar put it very well. Thank you all. And I hope this has inspired you and encouraged you to also pursue construction arbitration. And we hope to see many of you in SAM, Sharjah Amachang itself, or maybe in the future in some other arbitration proceedings against us as well. It would be great to have that. And yes, thank you so much. It's genuinely been an honor.
Thanks a lot, everyone. Thank you.
Thank you.
Goodbye.
Participants, before we bid adieu, I request if you can please fill out the form that is present in the chat box. Thank you everyone for joining us today. We will be ending the meeting in 5 minutes.